There is a patent in the records of the United States Patent Office that was filed in 1883, granted in 1884, and sold 11 months later for $10. The sale is documented in the patent assignment records at the National Archives, patent number 306,727. The assigner was a black man from Lynn, Massachusetts, named Ernst Matzeliger. The assignees were three white businessmen who understood what they were buying in a way that Matzeliger, who was dying of tuberculosis and needed immediate cash, could not afford to calculate. What they were buying was the shoe-lasting machine. Shoe-lasting is the process of attaching the upper part of a shoe to the sole. Before 1883, it was done entirely by hand by skilled craftsmen called handlasters who could produce approximately 50 pairs of shoes per day, and who commanded wages that reflected the irreplaceable nature of their labor. Matzeliger's machine could produce between 150 and 700 pairs per day, depending on configuration. It did not require a skilled craftsman, it required an operator. The three men who bought patent 306,727 for $10 formed the United Shoe Machinery Corporation. By 1899, United Shoe Machinery controlled more than 90% of the shoe manufacturing machinery market in the United States. The company's market capitalization in the early 20th century ran into the hundreds of millions of dollars. Ernst Matzeliger died in 1889, 5 years after his patent was sold. He was 37 years old. He had no money. He left his remaining shares in the company that had purchased his invention to a church that had been kind to him. The patent assignment record is in the National Archives. The sale price of $10 is in it. The subsequent transfer to United Shoe Machinery is in it. The financial history of the company built on his patent is in the corporate records of United Shoe Machinery, which are at the Baker Library at Harvard Business School. I came to this story the same way the competitor I've been studying came to the photograph in the Library of Congress, through an object that did not match the story I had been told. The object in my case was not a mysterious device in the background of a photograph. It was a number, $10, for a machine that transformed an entire industry. The number made no sense until I understood the context it existed in. And the context is the same context that explains Tesla and Farnsworth and every other inventor whose work was capitalized by someone other than the person who did the work. The patent system in the United States in the 19th century was theoretically accessible to any inventor regardless of race, gender, or economic status. The Patent Office did not ask for a photograph. It did not ask for proof of citizenship. It asked for a model, a description, and a filing fee. What the patent system did not provide was what happened after you filed. A patent is a legal instrument. Its value is entirely dependent on your ability to enforce it. Enforcing a patent in the 19th century meant filing suit in federal court, which required retaining an attorney, which required money, which required either personal wealth or the ability to attract investors willing to fund the litigation. An inventor who could not fund litigation could not enforce a patent. An inventor who could not enforce a patent had, in practical terms, a document whose value was exactly what a buyer with the resources to enforce it was willing to pay. $10 if you needed $10, and the alternative was watching the patent expire unenforceable. This is not a story about individual malice. The men who bought Matzeliger's patent were businessmen who understood the mechanics of the patent system and used them. The mechanics of the patent system were not designed to harm black inventors specifically. They were designed around assumptions about access to capital and legal resources that excluded most Americans and excluded black Americans almost completely. The result was a specific and documented pattern. It is in the Patent Office appeal records from the 1870s through the 1920s. It is in the settlement agreements that black inventors signed when corporations challenged their patents. It is in the assignment records that document the transfer of patents for prices that bear no relationship to the subsequent commercial value of what was assigned. I want to tell you about Granville Woods, because Woods understood the pattern clearly enough to try to navigate it, and his attempt to navigate it is documented in ways that make the mechanics of the system unusually visible. Woods was born in Columbus, Ohio in 1856. He was largely self-educated in electrical engineering, working in machine shops and on railroad lines while teaching himself the theoretical foundations of what he was building. By the early 1880s, he had begun filing patents. By 1887, he had filed more than a dozen. The patents were good. They were good enough that both Thomas Edison and Alexander Graham Bell, through his telephone company, challenged them. The challenges were not based on the merits of the inventions. They were based on prior art claims, assertions that Edison or Bell had developed similar technology earlier, which, if successful, would invalidate Woods's patents and transfer the intellectual property to the challenger. Prior art challenges were expensive to defend. They required documentation of the inventor's own development process, notebooks, correspondence, witness testimony, organized and presented by attorneys who charged fees that Woods, working in his own small shop, could not afford to sustain. Woods won his initial challenges against Edison. The patent record shows this. Edison acknowledged the validity of Woods's patents, and rather than continuing litigation he was losing, offered to hire Woods instead. Woods declined. He wanted to remain an independent inventor. He eventually sold patents to both Edison and Bell Telephone, not because he wanted to sell them, but because the alternative was continued litigation he could not fund. The sales are in the patent assignment records. The prices are in them. The prices are not $10. They are better than $10. They are not the prices that the same patents would have commanded if the seller had been white, wealthy, and able to enforce them indefinitely. Edison received the credit. Bell Telephone received the technology. The historical record of electrical engineering and telecommunications, written largely from the corporate archives of the companies that commercialized the technology, reflects what the companies did with the patents they acquired. It does not reflect the man who built them in a small shop in Columbus, Ohio, because his shop did not generate the kind of institutional documentation that archives preserve and make searchable. Woods filed more than 50 patents before he died in 1910. He died in poverty. His patent filings are in the National Archives, all 50 plus of them. The assignment records showing what he sold and for what prices are in the same archive. The gap between the prices he received and the commercial value of what he sold is calculable from the corporate histories of the companies that bought from him. Now, I want to tell you about Lewis Latimer, because Latimer's story is the one that makes the structural problem most visible, and because Latimer himself understood the problem clearly enough to write about it. Latimer was born in Boston in 1848 to parents who had escaped slavery. He taught himself mechanical drawing while working as an office boy at a patent law firm. By the time he was in his mid-20s, he was producing patent drawings of sufficient quality that inventors sought him out specifically. He drafted the patent drawings for Alexander Graham Bell's original telephone patent application in 1876. He drafted patent drawings for Hiram Maxim, the inventor of the machine gun. He was good enough at his work that Thomas Edison hired him in 1884 as a draftsman and technical expert. Latimer also invented things. His 1881 patent for an improved method of manufacturing carbon filaments for incandescent light bulbs was a genuine improvement over existing technology. It produced a longer-lasting, more reliably manufactured filament than the methods Edison's lab had been using. The patent is in the National Archives. The technical merit of the invention has been confirmed by historians of electrical engineering. What Latimer received for working at Edison's company was a salary. What he received for his carbon filament patent is a more complicated question, because the answer depends on whether you count the salary he was paid as an employee as compensation for the patents that his employment agreement assigned to the company. Most employment agreements in the electrical industry in the 1880s and 1890s contained provisions assigning all patents developed in the course of employment to the employer. Latimer signed such an agreement. His carbon filament improvement, developed while working for Hiram Maxim before his Edison employment, was subject to different terms, but the exploitation of that patent, like the exploitation of all the technology in the incandescent lighting industry, was shaped by the patent pools and cross-licensing agreements that the major electrical companies maintained among themselves. Patent pools excluded independent inventors by definition. They were agreements among the companies that had accumulated enough patents to make pooling advantageous. An inventor who had sold or been required to assign their patents to one of the pool members received nothing from the pool arrangements. The value flowed to the corporations, not to the people who had created what the corporations were now licensing to each other. Latimer wrote about this. He wrote a book called Incandescent Electric Lighting, a practical description of the Edison system, published in 1890. It is a technical manual. But in its preface, Latimer describes the relationship between invention and capital in terms that are unusually direct for a technical publication from that era. He describes the process by which a practical invention requires the aid of the capitalist to become commercially viable, and he describes the consequences of that dependency for the inventor who lacks the capitalist's resources. He was writing about himself. He was writing about Matzeliger. He was writing about what would later happen to Granville Woods and what had already been happening to black inventors across the country for decades. The book is at the Library of Congress. It has been there since 1890. The question the competitor asked about the mysterious device in the Library of Congress photograph was, how many times has this happened? How many inventions are in boxes with incorrect labels, filed by archivists who noted the anomaly and moved on? I'm asking the same question about a different kind of archive. How many patent assignment records show $10 sales? How many settlement agreements show black inventors signing away patents they could not afford to defend? How many corporate histories acknowledge the names of the people whose work they commercialized? The patent records are in the National Archives, all of them. The assignment records, the appeal records, the settlement agreements. They are organized by patent number and by date. They are not organized by the race of the inventor because the Patent Office did not record that information. The absence of that information from the official record is not itself a conspiracy. It is the same kind of structural indifference that appears throughout this archive, the same indifference that filed Tesla's laboratory photographs as eccentric workspace curiosities and that labeled the mysterious device in the Library of Congress photograph as unidentified mechanical apparatus. The history of invention is the history of which inventions were capitalized, patented, litigated, and written into the record by people with enough resources to make their version permanent. Matzeliger's machine is still making shoes. His name is not on the machines. In 1900, a woman named Sarah Good was not in the history books. She had been the first black woman to receive a United States patent in 1885 for a folding cabinet bed, a piece of furniture that could be converted from a bed to a writing desk, designed specifically for the small apartments of urban workers who could not afford to dedicate a room to sleeping. The patent is in the National Archives, patent number 322,177. It is dated July 14, 1885. The folding cabinet bed was practical, commercially viable, and addressed a genuine market need. Good was a furniture store owner in Chicago. She understood her customers. She built something they needed. There is no record of the folding cabinet bed being manufactured at commercial scale. There is no record of a licensing agreement, a manufacturing contract, or a sales partnership. There is no record of what happened to patent 322,177 after it was issued. The patent exists. The invention exists. The subsequent commercial history does not. This is the pattern the competitor identified with the photographs of anomalous technology. The object is real. The documentation of the object is real. What is missing is the institutional infrastructure, the capital, the legal representation, the commercial relationships that converts a documented invention into a documented commercial history. For inventors who had access to that infrastructure, the gap between patent and commercial history does not exist. The Edison Company's patents are documented from filing through commercial exploitation through the creation of an industry. The trail is continuous because the institution that held the patents had the resources to create and preserve it. For Sarah Good, for Jan Matzeliger before he sold for $10, for Granville Woods before the litigation costs forced his hand, the trail ends at the patent. The patent is there. What happened next is inference, absence, and the occasional assignment record showing a sale at a price that tells you what the seller's options were. I want to tell you about the assignment record that I keep returning to because it is the document that makes the mechanics of the system most visible. In 1884, a black inventor named Elijah McCoy filed patent number 307,618 for a lubricating cup for steam engines. McCoy had been filing lubrication patents since 1872. By 1884, he had more than 40 patents. His lubricating systems were so reliable that machinists and engineers began specifying the real McCoy when ordering parts, meaning specifically McCoy's systems rather than cheaper imitations that did not work as well. The phrase entered the language. McCoy's name did not enter the history of engineering with the same force. The assignment records for McCoy's patents show a consistent pattern across 4 decades of filing. His early patents were assigned to his employers or to investors who had provided startup funding. His later patents, the ones he filed as an independent inventor, were frequently challenged by larger companies, and the settlement agreements that resolved those challenges transferred licensing rights in ways that reduced McCoy's share of the commercial value his inventions were generating. McCoy died in 1929. He spent his last years in a state psychiatric facility. The connection between his financial circumstances and his health in those final years is documented in the medical records that his family has shared with researchers. His patents are in the National Archives. His assignment records are there. The companies that used his lubricating systems without adequately compensating him. That story is reconstructible from the assignment records, the challenge filings, and the settlement agreements. It has not been reconstructed systematically because no one has put all the documents on the same table. Now I want to tell you about something that the competitor's video about photographs does not address, but that the patent record makes visible in a different way. The competitor argued that the history of technology was written by the people who commercialized it, not by the people who invented it. That the companies with capital, lawyers, and institutional documentation created the record that archives preserved. The patent record adds a specific dimension to this argument, because the patent record does document the inventors who had capital and the inventors who did not. The assignment records show the transfers. The appeal records show the challenges. The settlement agreements show the resolutions. What the record shows, when you read it as a whole rather than patent by patent, is a system that was theoretically accessible to all inventors and structurally available only to those who could fund enforcement. A patent that cannot be enforced is worth what someone is willing to pay for it immediately, which is usually what the seller needs to survive. $10 if you are dying of tuberculosis. Whatever United Shoe Machinery or Edison Electric or Bell Telephone offered if you were being outlitigated by their legal departments. The history of invention, as written from the corporate archives of the companies that commercialized technology in the 19th and early 20th centuries, is a history of those companies. It is not a history of what was invented, by whom, and under what conditions. It is a history of what was patented, enforced, commercialized, and incorporated into a corporate structure that generated the kind of institutional documentation that archives preserve and make searchable. The inventor who sold for $10 is in the patent record. His name is on patent 306,727. But the history of the shoe industry was not written from the patent record. It was written from the corporate archives of United Shoe Machinery. And United Shoe Machinery's archives do not begin with Jan Matzeliger's name. They begin with the names of the 3 businessmen who paid $10 for what became a $100 million company. This is the structural problem Louis Latimer described in his preface in 1890. This is what Granville Woods was navigating when he sold patents he had won in litigation, because the cost of continuing to win was more than he could sustain. This is what Sarah Good confronted when her commercially viable, documented, patented invention disappeared into the archive without a subsequent commercial history. I want to be specific about what I am not saying. I am not saying that every white inventor was wealthy and every black inventor was poor. I am not saying that the patent system was specifically designed to harm black inventors. I am not saying that the corporate acquisition of patents from independent inventors was uniquely a racial harm. What I'm saying is that the structural disadvantages of the patent system, the dependence on capital for enforcement, the advantage of corporate legal departments over individual inventors, the tendency of the historical record to follow institutional documentation rather than invention itself, fell with particular weight on black inventors who faced those structural disadvantages alongside the specific exclusions of a society organized around racial hierarchy. And that the result is visible in the patent record if you read the patent record as an economic history rather than as a catalog of inventions. The patent applications are in the National Archives, the assignment records are there, the appeal records and settlement agreements are there. The gap between the prices paid for assignments and the subsequent commercial value of what was assigned is calculable from corporate histories that are in business school archives across the country. No one has assembled all of these documents on the same table and read them together as a systematic history. I have been reading them one by one. The pattern that emerges is the same pattern the competitor identified in the photographs of anomalous technology. The objects are real. The documentation is real. What is missing is the institutional infrastructure that would convert their documentation into the kind of history that gets taught. The history of invention is written from the records of the companies that commercialized what was invented. The companies that commercialized it were not, in general, the people who invented it, and the gap between who invented and who commercialized was not distributed randomly across the population of American inventors. Matzeliger's machine transformed the shoe industry. His name is not on the machines. Woods's patents improved railroad safety and electrical systems across the country. His shop is not in the histories of those industries. Latimer wrote the book on incandescent electric lighting. The industry it describes was built by the company that employed him. The patent record is in the National Archives, patent 306,727, filed 1883, assigned 1884, price paid $10. The history written from the corporate archives starts the story 11 months later with the company that paid $10. The question the competitor asked about the mysterious device in the Library of Congress was, how many times has this happened? I am asking the same question. How many assignment records show $10 sales? How many settlement agreements show the moment an invention passed from the person who built it to the institution that would capitalize it? How many histories start 11 months after the $10 changed hands, with the names of the buyers rather than the name of the man who was dying of tuberculosis when he signed? The records are in the National Archives. They have been there since the patents were filed. The patent is still in the archive, patent 306,727, Jan Ernst Matzeliger, shoe lasting machine. Assigned 1884 for $10. The history written from those $10 is worth hundreds of millions. The history written from patent 306,727 is this. The United States Patent Office records are available through the National Archives and through the Patent Office's own online search system at patents.google.com and through the USPTO's patent search at patents.uspto.gov. Patent assignment records, the documents showing transfers of patent ownership and the prices paid, are in the National Archives under the records of the Patent and Trademark Office. They are searchable by patent number. John Matzeliger's patent, number 306,727, is searchable. Granville Woods' more than 50 patents are searchable. Lewis Latimer's patent for carbon filament manufacturing, number 252,386, is searchable. Elijah McCoy's lubricating cup patent, number 307,618, is searchable. Sarah Good's folding cabinet bed patent, number 322,177, is searchable. Its assignment history, or the absence of one, is visible in the same record. Lewis Latimer's book, Incandescent Electric Lighting, A Practical Description of the Edison System, is at the Library of Congress. It has been there since 1890. His preface, in which he describes the relationship between invention and capital, is in it. The corporate archives of United Shoe Machinery are at the Baker Library at Harvard Business School. The gap between what Matzeliger received for patent 306,727 and what the company that bought it was worth within a generation is calculable from those records. The history of invention is written from the corporate archives. The patents are in the national archives. The history that the patents tell is different from the history that the corporations tell. Subscribe, because next week we open another file.